Okay, we'll get started. Good evening, and thank you for joining us. My name is Mariela Colon, and I'm a librarian with the Civic and Cultural Literary Engagement Department at Chicago Public Library. Tonight's virtual event is part of our Law of the Library series in partnership with Evanston Public Library and the Chicago Bar Association. We continue to be grateful to CBA for their continued support for this public information series. During tonight's program, we'll be monitoring an online chat for questions from the audience or Q&A in the middle and also at the end of this program following the conversation. So please feel free to put those questions in the Q&A button at the bottom of your screens. We will get to them while time allows. I'm now pleased to introduce our speaker for this evening. Tonight's speaker is attorney Ashley Stead of McGann, Ketterman, and Rue. She is also the chair of the Chicago Bar Association Labor and Employment Law Committee. Thank you again for attending this program, and with that, I will hand it over to our speaker to get started.
Thanks, Marielle. And thank you everyone for joining us tonight. So as Marielle said, I am a labor and employment attorney. In my current practice, I represent mostly labor unions, but we do some individual employment law cases as well. So tonight's program, we're going to cover your sort of basic employment rights that everyone should know or needs to know in the workplace. And then in part two, we'll get into a bit of a contract negotiation discussion. So we will have sort of a two-part series this evening. And we will do questions as we go after that first part. If this is your first time attending a Law in the Library series, there's other events that you can attend coming up. Here are a few other dates that you can attend for future topics. So for part one, we're going to go over sort of those basic rights that all employees need to know. We'll cover issues such as at-will employment, fair wages, and benefits. Some of the new paid leave laws, I'm sure a lot of you have heard about that, especially with the city of Chicago recently passing an ordinance. And then we'll talk about protections against discrimination and harassment. So Illinois is an at-will employment state. For those of you who haven't heard the phrase at will, this applies to most employment in the state of Illinois. The exception would be where your employment is covered by a contract, whether that be an independent contractor agreement or a collective bargaining agreement. Those have established different relationships. However, generally speaking, Illinois is at-will employment, which means that the employer has the ability and the legal right to dismiss an employee for any reason at any time and without warning, so long as that reason is not illegal. And we'll talk about sort of what some of those illegal reasons may be later on. So as I mentioned, your contract, if you are a contract employee or covered by a collective bargaining agreement, might have additional terms and conditions on how you can be disciplined or how your employer can terminate you. But even some employment contracts also state that this relationship is an at-will employment relationship. So you may be wondering, how do I know if I'm governed by an at-will employment relationship? A good rule of thumb is to assume that you are in most cases, but also your employer should probably have a handbook or a personnel policy that will typically state that this is an at-will employment relationship. Sometimes if you've received a pre-employment offer letter or some sort of terms and conditions of employment, those will also clarify that it is an at-will employment relationship. So if you leave with anything tonight, the first thing I want you to do is make sure you are familiar with your employer's handbooks and policies and any employment contracts that you may have. And we'll talk more about those contracts as we move forward. So we're going to start with sort of the basics, which is minimum wage. I'm sure most folks on here are familiar with minimum wage laws. In Illinois, we are working up towards a $15 minimum wage in the state, and the city of Chicago is inching beyond that at this point. So as of January 1, 2024, for folks outside the city of Chicago, throughout the state, the minimum wage is currently $14 per hour. And for tipped workers, that is $8.40 per hour. So tipped workers are those folks like restaurant servers who earn tips as a part of their employment, and those tips then offset their minimum wage amount. So they're actually paid less per hour because the tips are sort of making up the difference there. Now, in the city of Chicago, they have their own ordinance that has been increasing the minimum wage gradually. And as of July 1st of last year, 2023, that minimum wage is $15.80 per hour for smaller employers with 21 or more employees, larger employers. And then if a smaller employer has 4 to 20 workers, then they pay their workers $15 an hour. Chicago also has a tipped workers wage, which is $9 an hour right now. Although the city did recently pass an ordinance and will be phasing out the tipped worker minimum wage. So that way tip workers make the same amount as everybody else as beginning in 2028. So that is also on the horizon. So in addition to your minimum wage amounts, most hourly workers and even some salaried employees are covered by the state overtime laws and must be compensated at time and a half for any time they work beyond 40 hours a week. Now, this does depend on the type of work you do, the position that you're in, but again, most hourly employees do receive that overtime pay. So we talked about tipped workers, and one thing that is important to understand, especially if you work in a tipped position and you receive the tip worker minimum wage, the idea of the reduced minimum wage for workers who receive tips is that the tips make up the difference, right? That the tips are supposed to bring them up to whatever the minimum wage amount is, whether it be $14 or $15. However, across the state, whether you're in Evanston, Chicago, Illinois, wherever you may be, if you are a tipped worker and your hourly wages plus tips do not get you up to that minimum wage, then your employer is supposed to make up the difference. So what does this mean? Well, if I'm a server and I'm working a shift and a storm hits the city and we are just empty, no one comes to visit, we don't have any takeout orders, and I don't make any tips that night, then my employer is supposed to pay me the minimum wage for all those hours that I was working at that night, even though I didn't earn any tips. So this is important to know because unfortunately a lot of folks, especially in the restaurant industry, don't realize that they do have that right to make up the difference for their employer to make up the difference if they're not earning those tips. Another key thing to know about the minimum wage laws is that in both the state and the city, domestic workers are entitled to minimum wage. So what's a domestic worker? Domestic worker are those folks who perform work typically around the home. So housekeeping, maid services, nannies, babysitters, cooking, etc. Those folks are also entitled to receive minimum wage. And the state of Illinois has a domestic workers bill of rights in statute that does provide protections for those workers as well. So that's another place that the minimum wage often comes up in that folks maybe just aren't aware of. Now, we do have the tipped wage, the tipped worker minimum wage, which is lower than the standard minimum wage. In addition, there is a lower wage for youths. So folks who are less than 18 years of age, under 18, can be paid $12 an hour if they work less than 650 hours per year. So 650 hours generally means they're part-time. If they're part-time, they're not working full-time, then they could be paid as little as $12 an hour. However, it's important to remember that in the state of Illinois, you really can't be working under the age of 14, except for some very limited circumstances. And for those who are 15, 16, and 17, they typically have to get a work permit through the Department of Labor to be working. So there is different rules and requirements for those individuals, but as far as minimum wage requirements go, they can be paid as little as $12 per hour. So when we're talking about minimum wage and being paid for the work that you're performing, a lot of folks, when they leave their employment, are concerned about their last paycheck. They're concerned about any benefits that may be owed to them. They're concerned about receiving that last paycheck for any time that they have worked. So upon termination of employment or upon your employment's end, you are under law entitled to your final compensation, so any hours that may be owed to you. This also includes any vacation time, paid vacation time that may be owed to you, or bonuses, or any amounts that the employer generally owes you must be paid to you on your next regular paycheck. So at the next pay period, you should get all of that paid out. There shouldn't be a delay in getting your vacation time or your final paycheck from your employer. It is also unlawful in the state of Illinois for employers to take unauthorized deductions from paychecks unless they're allowed by law. So everyone's familiar with taxes. We know that our employers are deducting federal and state taxes from our paychecks. If you're a member of a union, you may have union dues deducted, healthcare benefits may be deducted, etc. But anything that's not authorized under law and typically by you is not allowed. It's not lawful. This brings us to the next consideration, which is reimbursements for employees. So employees sometimes incur expenses. They have to perhaps use a vehicle to travel for work. If you work remote or from home, you may have a computer like the one we're on right now, or a cell phone perhaps, things that you use to perform your job duties, to perform your work. Under Illinois law, employers must reimburse employees for all necessary expenditures that are incurred in the scope of their employment. So what does that mean? So if my employer tells me, Ashley, we're going to have you work from home, you have to have a laptop, a printer, and a phone that we can call you on at any point between 9 and 5 a.m. or 9 a.m. and 5 p.m. Well, all three of those things, the laptop, the printer, the phone, are all necessary to my employment, and they're expenses that I'm incurring in the scope of my employment while I'm working. So those are things my employer would have to reimburse me for. And they
Ashley, I'm sorry. Could you check your sound really quick? It just you went really faint. So
Sure.
there, now it's perfect.
Okay, sorry about that.
Yep.
So if my employer says that I need a computer, I want to make sure my sound's working. Sorry about that.
Yep.
Are we good?
Okay, thank you.
So if my employer says, Ashley, you need to have your computer, printer, and cell phone to do your job, and I have to purchase these things, then my employer must reimburse me for those devices that I must have to do my job, but not just the devices, but also the services that may be associated with them. So what does that mean? If I need to access the internet, my employer may have to be paying for the Wi-Fi that I'm using to access the internet. If my cell phone is being used, my employer is calling me on that, and I'm using that for my job, my employer may also have to reimburse me for some of my cell phone expenses. And we don't just see this in the work from home space either. We'll see this when folks are going into work where they may have to use their personal device to perform some function of their job. So some companies will require employees to clock in and out on their phones, or maybe use their phones to scan products or to, interface with their systems, whatever the job may be. In those cases, if that is a mandatory expense of your employment, then you may be entitled to some reimbursement from your employer for those things. We also have the more traditional expenses such as uniforms, other types of equipment you may need to perform your job. Those kind of things must be reimbursed by your employer. So these are just some other considerations when we're talking about your minimum wage and just wage payments in general. Another consideration when we're talking about wages is equal pay. So in the state of Illinois and under federal law, it is illegal for employers to pay unequal wages to men and women for doing the same or substantially similar types of work. So what this means is that sex cannot be the basis for which my employer is paying me more or less than my coworkers, than my colleagues.
Unfortunately, throughout the country, we do still see a pattern of women being paid less than men per hour. And that factor is even worse when we look at women of color, particularly African American women, who tend to be paid significantly less than white males do. So under law, it's illegal for your employer to pay unequal amounts. Now, there are exceptions. The exceptions include seniority, merit system. If there is some way to quantify or explain the difference, such as, this person has been here the longest, or maybe they have higher degrees, there may be some, rational basis that explains the difference. So long as it's not based on their gender, it's typically okay. In Illinois, the Equal Pay Act also specifically applies to African American employees because, as I mentioned, statistically speaking, they tend to see the biggest disparity amongst that population of workers in unequal wages. We also do see it in the Latino community as well and some other minority groups, but it tends to be the worst with African American population. So that's another consideration if you are find out that your colleagues or your coworkers are being paid significantly more than you for the same or substantially similar work, then there's a possibility you may have a claim for an Equal Pay Act violation. So we've talked about minimum wage. We've talked about different factors to consider with being paid your due wages. So when you're not paid your due wages, we call that wage theft, which actually is both a civil and criminal offense in the state of Illinois. So if your employer engages in wage theft, it actually could be a criminal action. So wage theft simply means the non-payment of wages that are owed. So this includes my hourly wages, right? My, being paid for showing up to work and doing my job. But it can also include my benefits. It can include my paid time off. It could include if I'm getting payments towards my healthcare benefits and things like that. Anything that is wage or benefit related falls under the umbrella of wage theft. So some examples of wage theft are, obvious. The most obvious is just simply not paying an employee what they're owed. But we tend to see it more in these discrete areas where perhaps employees are just being paid straight time for hours they work beyond 40, right? They're not getting their overtime pay. That will be a case where they're still getting paid, but it's not the full amount that is owed to the employee because they're not getting their overtime pay. We also see this pretty frequently in the construction industry where prevailing wage comes into play. It's a different type of minimum wage for construction workers. And we'll see them, they're going to be paid, but the employer might not be paying them the prevailing wage, the wage that they are owed. So that's another form of wage theft. We've talked about the service industry workers and tipped workers. Unfortunately, wage theft is also common in that field. Because of the tips. And so an example would be if, there is a tip pooling in the workplace where all the servers are putting all their tips together, and at the end of the night, those tips are being divided out. If not all the tips are in fact being divided out to the servers, that wage theft could be occurring. What we do see with tips as well is issues where, let's say that you are supposed to be tipping out the bartender at the end of the night, right? You're the server tipping out the bartender, and every night you're tipping out the bartender maybe less than what you're supposed to be, right? Every night or every other day, you're giving them $5 less here, $3 less here. That's also a form of wage theft, right? So if they're not getting the tips that are owed to them, that's a form of wage theft. We talked about expenses. So not being reimbursed for expenses that are owed to you is also a form of wage theft and can be civilly or criminally pursued against your employer. And then similarly with meal breaks, if you're not being afforded your breaks that are owed to you, that could be a form of wage theft as well, because you're being required to work but not perhaps being paid for that time you're being required to work. So this is another issue that comes up when we think about minimum wage and our other just overall, this happens to salaried workers as well. It happens, unfortunately, in many different ways. So I mentioned meal breaks, and I thought it would be helpful to briefly talk about what is required under Illinois law as it applies to meal and rest periods. So Illinois has the One Day Rest and 7 Act, which requires all employers to provide employees at least 1 day of rest for every 7 consecutive days they work. So this law used to say, between the period of Monday through Sunday, you got to get 1 day off. But it was recently amended because we recognize that the workplace just isn't maybe what it used to be. Worker schedules they vary, they're different. We don't all work the typical Monday through Friday anymore. So now it's just any 7 consecutive days, you're entitled to at least 1 day of rest. There is the ability for folks to voluntarily work that 7th day if they're trying to get overtime or help their employer meet a goal or quota, but that has to be voluntary. Your employer cannot force you to work that 7th day. In addition to having the 1 day of rest, you're also legally entitled to rest periods throughout your day. So for any employee who's working 7.5 continuous hours, you must be allowed a meal period of at least 20 minutes. And that has to occur no later than 5 hours after the start of your day. So what does this mean? It means you're entitled to a lunch break, at least 20 minutes in length, hopefully a little bit longer, but at least 20 minutes from the time you started your day. Now, if you work a longer shift, let's say you work a double or you're beyond that 7.5 hours, then you get an additional 20 minutes when you work a 12-hour shift or longer. So once you hit 12 hours, you're owed another 20 minutes of breaks. Now, another thing to keep in mind is that bathroom breaks are sort of not considered breaks necessarily under the law. You don't have to clock out to use the bathroom, right? You may have to clock out for your meal period that you're entitled to, maybe an unpaid meal, but you don't have to clock out for the bathroom. And the law requires that your employer give you reasonable bathroom breaks when need be. So when we think about wage theft and we think about rest periods, if you're not getting that time off, or if you're being forced to work and then not being paid for it, that's where we may see these two issues intersect, rest periods and wage theft. So I'm going to move to our next topic, which is unpaid leave, and then we'll talk about paid leave. So there's several different statutes at the local level, at the state level, and the federal level that provide different forms of leave. We could do a whole seminar on all of those, so I'm just going to hit a few of the big ones. And these are, the ones I'm talking about now are for unpaid leave. So what this means is that you are entitled to take time off from work to deal with whatever the issue may be. And you're not paid for it, but you are entitled to get your job back when the leave is over. So some of the examples include VESA, which is the Victims Economic Security and Safety Act. And this lets all employees who are victims of domestic or sexual violence, or they have a family member who is a victim of domestic or sexual violence, to take up to 12 weeks of unpaid leave to help seek medical attention, legal assistance, counseling, etc. It doesn't have to be the full 12 weeks. It doesn't have to be 12 weeks consecutively. You could take a day here, some time here. But this way, the state really wants to support individuals who are seeking treatment, seeking help. And this way, if you don't have PTO or paid time off you can take, this law, VESA, gives you a safety net to say, listen, it's not paid, but at least you'll have your job back when you get back. This is also important for folks who maybe have to attend court for different reasons following an instance of domestic or sexual violence, or just violence in general. If they're going to court hearings, etc., VESA would cover that type of leave. Similarly, Illinois has the Family Bereavement Leave Act, which provides up to 2 weeks, so 10 working days of unpaid leave following the death of an immediate family member or a lost pregnancy, whether that's through IVF or some reproductive procedures or just a miscarriage. You're allowed to take up to 10 days to grieve, essentially. And if an employee loses, God forbid, more than one family member in a 12-month period, they are entitled to take up to 6 weeks. So again, this law is intended to cover those, incidences of loss where you need to take time off to maybe plan a funeral or to attend services, or also to seek support and guidance, grievance counseling, and things of that nature. And then lastly, hopefully everyone on this webinar is familiar, at least have heard of FMLA, the Family Medical Leave Act. This is a federal law that provides employees up to 12 weeks off for medical or family caregiving. So this is if I'm sick and I need to enter medical treatment, I could take up to 12 weeks unpaid time off from work to deal with my medical issue, or if a family member is sick and I need to caregive for my spouse, my child, I can also then take that time off. Now, FMLA typically applies to folks who work full time and have been working for their employer for about at least a year, and that those employers are on the bigger side, so they have to have at least 50 employees at all of their locations combined. It doesn't necessarily have to be your office, but if they have at least 50 employees, you're covered. So again, these are all forms of unpaid leave. You're not going to be, unfortunately, making money, or getting paid while you're on these leaves, but you do have that job security. So when you are ready to return to work, you have that guarantee that your job will still be there. So let's then talk about what we can be paid for, what paid leave options are available. So the state did pass a law. It's called the Paid Leave for All Workers Act. And that just went into effect January 1 of this year. So we're only in month 2. And this law requires that all employers throughout the state give their employees the ability to earn up to 40 hours, so about a week's worth, of paid leave from work to be used for any reason. Why is that important? Well, typically we think of paid leave as vacation time or sick time or personal time, right? There's usually been historically buckets of what we can take leave for. This act says, listen, we actually don't care what the leave is for. You have a flat tire, you have a cold, right? Whatever it may be, you have up to 40 hours a year to take leave for what you needed. And the law even says that employers may not require workers to provide a reason. So you don't have to explain to your boss, oh, I have this, doctor's appointment, or I have this personal matter I'm dealing with, right? You just say, hey, I'm using my paid leave. Now the law allows workers to accrue the 40 hours. So you can earn 1 hour of paid leave for every 40 hours you work. But it also gives employers the option to what's called front load, which means employers can say, we're just going to give you all 40 hours up front and you use them as you need. So that's really up to the employer. Now, if your employer already offers you some type of paid leave, or let's say you're covered by a collective bargaining agreement or a contract that has paid leave provisions in there, then this law likely won't apply, so long as you're getting at least 40 hours of paid leave for the year. So, and these hours can roll over as well if you don't use them into the next year. So that's at the state level. The city of Chicago also passed a paid leave ordinance themselves recently, and that goes into effect July 1 of this year. So it hasn't gone into effect yet, but it will be soon. And that also allows workers to accrue up to 40 hours of paid leave for any reason, to be used for any reason. But in addition to that 40 hours of paid leave, you also accrue up to 40 hours of paid sick leave. So this means you have potentially up to 80 hours of paid leave per year, and you have the ability then to say, I need to use this bucket for sick leave, and then I have this other 40 for whatever I may need. Much like the state law, you can, your employer can either front load or require you to accrue the hours, but you can also roll hours over that you don't use. So these are very exciting developments for a lot of workers who didn't have any forms of paid leave before. They apply to most employment. So again, whether you work in a restaurant, whether you drive a taxi, right? Like if you're an employee, you're likely entitled to paid leave under one or both of these laws. So shifting away from wage and hour and pay, we're going to talk about briefly discrimination and harassment and just generally what your protections are in the workplace. So under federal, state, and local laws, so the city of Chicago, the city of Evanston, all prohibit discrimination, harassment, and sexual harassment, as well as retaliation, based on an individual's status as a member of what's called a protected class. So a protected class are classes of folks that are identified under law as being particularly vulnerable and needing protection. So in Illinois, protected classes include race, color, religion, your sex, gender, your national origin, ancestry, your age, your order of protection status, your marital status, sexual orientation, gender identity, any physical or mental disabilities, but it also goes to conviction records, military status, and whether you were unfavorably discharged from the military, pregnancy, citizenship, arrest records, and familial status. So a lot more classes are protected in Illinois than other places, even under the federal law. When we talk about discrimination, harassment in the workplace, what this typically means is that your employer, whether it's your boss, your supervisor, or coworker, someone in your workplace, is perhaps treating you differently.
Hi, Ashley. I'm sorry, your sound went very low again.
Thank you for. Is that better?
Now it's better, yes.
Okay. Sorry about that. So what does discrimination in employment apply to? And there is also protections against discrimination in housing, in public accommodations. That's, again, a separate webinar. Today, we're just focusing on employment. But discrimination in employment includes anything that impacts your terms and conditions of employment. So that could be if you're hired for a job, if you're promoted for a job, or if you're laid off, terminated, or separated from your employment, right? Demoted. Those are all sort of terms and conditions. But also pay, as we've mentioned before, pay can be a term or condition. Your job assignments, where you're being placed, whether you're being transferred somewhere, right? Your working conditions, such as what benefits you have access to. Do you have the same PTO benefits as your colleagues, right? Can you take advantage of employee programs the way your colleagues can? All of these things can be considered a term and condition of your employment. So again, under all levels of law, whether that be the federal, the state, or the local, discrimination, harassment, sexual harassment are all prohibited in the workplace, and your employer can be held liable for you experiencing discrimination and harassment. Now, a good rule of thumb, without getting too deep into this, is that if you are experiencing discrimination or harassment, it is really important to report that to your employer. You want to give your employer an opportunity to try to address the situation, correct the behavior, and hopefully help you not experience discrimination and harassment. So it is important to put your employer on notice. If you are a member of a union governed by a collective bargaining agreement, then you also can contact your union and they may be able to help you file a grievance and go through those processes as well. So again, just high level, discrimination, harassment is illegal when it applies to one of the protected classes we've discussed here in Illinois. So we covered a lot this first half about employment rights. The second half will be about contract negotiations. But before I move on, I want to see if folks have questions here.
Okay, so if you have questions pertaining to any of the content that Ashley just did, let me pause recording.
Thanks. All right, so we're going to move to part 2, which is the contract negotiations. I also apologize about my microphone in the first half, so hopefully we don't have those same tech issues going forward. So I want to talk about contract negotiations because in my practice, what I deal with a lot is folks who are working for an employer. Maybe they've been there 6 months, maybe they've been there 6 years, and an issue comes up, right? They are maybe having poor performance reviews, they are concerned about layoffs or their benefits, whatever it may be, and they don't know what their rights are, but they have an employment contract. And unfortunately, what we see all the time is that employees don't know what rights they have or don't have under their employment contracts because they probably just didn't read it good enough when they started their employment. So an employment contract can be any sort of written instrument that, written or oral for that matter, that is an agreement between the employer and the employee about the terms and conditions of employment. So it could be as simple as an offer letter that says, Dear Ashley, we would like to extend you this offer of employment. You'll be paid X amount. You'll work full time in our Chicago office. Here's your benefits, bonuses, etc. That letter with my acceptance is essentially a contract between my employer and I have agreed to these terms that they're offering me. So that's a more informal contract. In other cases, you'll have much more formal contracts that have all of the terms and conditions spelled out with additional provisions that we'll talk about that you have to sign, that you have to execute before starting your employment. And then we'll also see contracts that are collective bargaining agreements. So what this means is you are a member of a union and your union has negotiated on your behalf a collective bargaining agreement with the employer that lays out the terms and conditions, the wages, the benefits, grievances, all of those sorts of things with the employer. So and you may not have even been a part of the union when they negotiated that contract, but by virtue of becoming a member of the union, you are covered by that collective bargaining agreement and you are entitled to all the benefits and rights that that collective bargaining agreement offers you. So some contracts we see have what's called a fixed term. So this means maybe I'm being signed on to work somewhere just for a temporary period. So Ashley, we want you to come join us, but it's only a 6-month job. This is a temporary position and it'll usually have a start and end date. That's a fixed term. But generally, most contracts that we see with individuals and their employers are indefinite. There is no definite term. So it's just, hey, Ashley, come work for us and, we'll see how the relationship goes. If it's an indefinite contract, again, usually that's because you're an at-will employee and your employer can terminate you at any time. Collective bargaining agreements typically have usually a 3-year term, sometimes 5-year terms, and they are then renegotiated by the union when those contracts are set to expire. So those are the different type of employment contracts we've seen. Again, employment contracts generally include things like your job description and duties. So if you have an employment contract, it's important to know what is expected of you as an employee, right? I've seen cases where individuals have been terminated and they're like, I don't understand why I was terminated, why I was let go. And it's because they weren't performing all of their essential job duties or they weren't satisfying the full description of their employment, right? And so you need to be familiar with that. Your employment contract also typically outlines your compensation and benefits. So whether this is your hourly pay, your salary, whatever healthcare benefits you may have, all of those things were typically outlined in an employment contract. Now, we spent the first half of today talking about benefits like paid leave. What's important to know is most of your rights, almost all of your rights that are afforded to you under law cannot be waived in a contract. So what that means is your employer can't say, hey, Ashley, I want you to agree that we'll pay you an extra $5 an hour, but you're not getting any paid leave. You're not getting any paid vacation time. I legally, even if I agreed to it, that would be unlawful. It'd be a void contract because I cannot waive away my rights under law in an employment contract. Now, there are exceptions with collective bargaining agreements, but that's because those are negotiated under federal laws and with the union. So there are some differences there that we don't need to get into. But as a good rule of thumb, you cannot waive your rights under your employment contract. Some employment contracts will have termination clauses or sort of disciplinary clauses. So it'll talk about how an employee may be disciplined. Some employers use progressive discipline, so they'll start with a warning. Maybe there'll be a suspension. Maybe there'll be some other levels that you go through before terminated. In most cases, even if an employer says, hey, if there's an issue, we'll start with a warning, we'll have a meeting, but most employers reserve the right to just terminate at will. So even though a contract or a personnel policy or handbook might say that we're going to take these various steps, that doesn't mean the employer is always going to. They usually reserve their right to fire you at will if needed. But those provisions are also important to know, because if you ever end up in a position where you're concerned about termination, you'll want to know what your contract says. Some really big contract provisions that you need to be aware of on the front end, so when you're negotiating a new contract for a job, are non-competes, non-solicitations, and confidentiality clauses. So non-competes and non-solicitations effectively say, when I leave this employment, I can't either compete with my employer, I can't perform services in the same industry, or I can't solicit their clients or employees. Now, Illinois does have the Freedom to Work Act, which prohibits non-competes and non-solicitations for a lot of low to medium wage workers, so that they're straight up unlawful for workers who typically make under $75,000 per year, but not in all cases. And so these are very, very important to know. I've seen folks who work in industries like finance or banking or various sort of white collar industries where they'll have these. But I've also seen them in the restaurant industry. I've also seen them in industries where you may not have thought there would be this non-compete, non-solicitation. So these are something you have to be on the lookout for. Similarly with confidentiality clauses cannot prevent you from reporting unlawful activity, harassment, or discrimination. I don't care how broad they are written, you still maintain the rights to report those sorts of things. But there's something that you also want to keep an eye out for. So some tips when dealing with contract negotiations are to make sure you've read your contract thoroughly and you understand it. So sometimes that means you have to reach out for legal help and seek legal advice. You don't always have to hire an attorney. The Chicago Bar Association does have a referral network, but there are free legal aids out there. There are, on the Department of Labor's website, you can look up certain things where they have frequently asked questions or guidance. You just want to make sure that you've read and understand the contract thoroughly. Sometimes it's as simple as maybe talking to a friend or your spouse or somebody who has maybe experienced this before, and they can kind of give you their experiences. But don't sign a contract if you don't know what some of the provisions state. This also means if the provisions are ambiguous, or if they're vague, or if you think that maybe they're imposing unfair terms, you don't want to sign those contracts either. You want to either negotiate those terms out or let the employer know that you need those terms amended or changed before you can sign the contract. It's also important to keep all documents that you receive from your employer, whether that's your contract, your personnel handbook, any trainings you've undergone. You want to keep your own records, right? We've talked about personnel records and how you do have a right to those. But again, in many cases, employers don't always turn them over readily or easily. And so it's really important that you hold on to those records yourself. Keep a file somewhere, stash them away, and then make sure that you refer to them whenever you're having sort of an issue in the workplace. And then lastly, if there's any changes to your employment or to policies in the workplace, make sure you have those amendments and keep those. So as Marielle said, there are places that you can go for more information and for assistance on specific legal issues you might be having that involve labor and employment matters. The Department of Labor is a great place to start for all things wage, hour, benefits, employment, etc. Department of Human Rights is your go-to for anything that has to do with discrimination, harassment, retaliation. those types of issues in the workplace. But both the city of Chicago and the city of Evanston also have their own sort of departments on workers' rights or labor standards. So those are also additional places you can go to for more information or assistance on legal issues you might be experiencing. So we're going to open it up for questions with the few minutes we have remaining on the contract negotiations. But before I do that, I just want to remind everyone that the Chicago Bar Association does have a lawyer referral service. If you are seeking legal advice or legal counsel on a specific labor and employment issue, you can go to our website or call the number on your screen, 312-554-2001.
Okay, so that concludes the lecture portion of the program. I'm going to go ahead and stop recording at this point and we'll return to questions.